Any mention?
May it please your Lordship, I beg to mention item number 5, Lordship. Lordship, I am praying 2 weeks' time, Lordship, for this matter.
I appeal for the responding, Your Lordship, and no objection, Your Lordship.
On prayer made on behalf of the petition, list after 2 weeks.
Obliged, Lordship.
Yes.
Supplementary cause list, item number.
Also, I beg to mention item number 10, Lordship.
Yes.
Prayers, Madam, we list after 2 weeks, Lordship.
No, that is for reference. It has come for reference, isn't it?
Yes,
It is for
Lordship.
mediation, reference.
Yes,
for
Lordship.
it. It is not.
Apologies.
Yes.
Number 4 is not mediation. Number 4 is not mediation.
My Lord, item 4 is correct to 10.
Anyway, let us see. Let us see what happens to 10 first, then we will see what.
My Lord.
Yes.
Please, Your Lordship. Lordship, I beg to make a mention of item 3.
Yes.
Lordship, I'm praying for accommodation, Your Lordship, in this matter. Senior counsel is out of station.
No objections, Lordship.
Your prayer has been made by Mr. Karim, Learned Counsel. On behalf of Mr. K. Paul, Learned Senior Counsel, appearing for the petitioner to adjourn the matter. So, Mr. Karwala, Learned Senior G has no objection to the prayer. Prayer allowed, just after 2 weeks.
Hello,
Yes.
Supplementary cause list, item number 1.
May it please your Lordship.
Wait. Yes.
Lordship, I beg to mention item number 8.
Mention in time. Yes. 8.
Yes, your Lordship. Your Lordship, praying that this matter may come up
These
after
are for mediation. We'll see. We'll see. These are for reference to mediation, nothing else. Yes.
Yes, Your Lordship, we have filed an application under under Article 227 regarding the said order of 13/10 of 2025 passed by the Learned Court, Presiding Officer of District Council Court in the title suit 112 of 2022. In this case, Your Honor, the petitioner have filed a title suit along with the order 39. However, after they also made a paragraph in the plain. It was in paragraph 3 of the plain, annexure 1, Your Honor, annexure 1, page 12, that the suit has already been instituted by the predecessor in interest of the petitioner against the predecessor in interest of the respondent.
Just go slow, go slow. You're referring to page?
12, page 12, annexure 1.
You are the plaintiff.
Para 3.
You are the plaintiff before the trial court.
Yes, we are the plaintiff in the status.
Yes.
Okay. We have filed that.
Para 3, yes.
It says that the petitioner in interest have already instituted
Which paragraph you are reading?
that the title suit being number 6 of
Which paragraph you are
1970.
reading? Which paragraph you are reading?
Paragraph 3, Your Honor.
At page 13.
Yes, page 13, Your Honor.
Did you read? Yes. That the land of the plaintiff.
Yes, that the land of
Just
the
read,
plaintiff was
yes,
illegally
yes.
occupied and encroached by private individual and predecessor interest of the plaintiff had instituted a suit before the subordinate district council, Kasiel Sholongs, being the title suit number 6 of 1979 for ejectment, money profit, and permanent injunction, and the suit was decreed. However, the judgment and a decree could not be traced. Further, the records of Title Suit 6 of 1979 may be called for. The records also have been called for in this case, Your Honor. However, it could not be traced.
Finish reading fast. If you just finish reading, then.
Yes. Further, the defendants are also not the legal heirs of the legal representative of the defendants in the Title Suit 6 of 1979.
So,
So after they have filed this, the respondent in third appearance However, they didn't file written statement. They filed an application under Order 7, Rule 11. In that application, they also made a statement under Annexure 4, Your Honor.
Page.
Annexure 4, page. Annexure 4, page 38, para 6.
Yes.
Yes, that the petitioner submits that para 3 of the plaint makes it clear that the opposite party's predecessor in interest have instituted a suit against the predecessor of the petitioner, and the suit was decreed in their favor. Therefore, on the admission of the opposite party plaintiff, the suit is barred by the principle of res judicata as envisaged under Section 11 of the Code of Civil Procedure.
Yes.
So after the order, a hearing was done on this article, on this application, and
This
the
application under Order 7, Rule 11 was
Order
heard.
7, yes,
Then what happened?
it was the order was passed.
What was the outcome? The trial court decided in which way?
The order, it was this application was dismissed by the learned court below.
So it was in your favor then. Order was
Yes,
in
it
your
was
favor.
in our favor.
Yes. Then Order 7, Rule 11 is applicable,
Yes,
isn't
Annexure
it?
6. Annexure 6. Yeah.
Okay. Then what happened? Then thereafter what happened?
After the order was passed, it was we have filed immediately after that. We have filed an application under Order 12, Rule 6 for the admission made in by the respondent in Para 6.
Order
After-
7,
Orders
Order 12,
12,
Order
Rule
12.
6.
That is with regard to admission.
Yes, it is
So
application.
which part has been admitted? This is Order 7, Rule 11 application. So how defendant can admit something in Order 7, Rule 11 application?
Yeah, it was. We have.
Can
done
it be
a hearing.
regarded as admission?
Yes.
Order 7, Rule 11 is nothing. It only speaks about what you have stated in the plaint. It is not a statement by defendant.
But also they have not denied regarding that.
Can it be admission? Can it be treated as admission? What is admission?
Admission is something that you admit
Yes.
for that
So
has
where
been.
is and in which way it can be admitted? Can it be by Order 7, Rule 11 application? Order 7, Rule 11 application only refers to what you have stated in your plaint. Anyway, then what happened after you filed that order? Order 12, isn't it? Yes, application. Then what happened?
They have not filed any show cause regarding that.
Doesn't matter. Then what
And
happened?
however, after 1 year of this, the learned court below passed an order that since this appeal was dismissed by this order,
Which appeal?
they have also filed an appeal before the judge of the district council court.
Appeal against?
Appeal regarding the order 7, Rule 11.
Okay. Appeal against rejection of Order 7, Rule 11.
Yes.
They preferred an appeal.
It was the
So
appeal.
that appeal was also dismissed.
Yes,
So appellate court's order also was in your favor.
yes, Your Lordship.
But then your grievance is
After that, regarding this applications, also under Order 12 Rules, an order was passed that since the appeal was dismissed by the appellate court, so this order, the application also was dismissed on that basis.
where is that order?
Order is Annexure 8, Annexure 9. Your Lordship.
What prayer you have made in this revision application before this court? And why it's a revision under 227?
Annexure 9, page number 105.
Annexure 9. Annexure?
Page number 105.
10? What is the page number? What is the
105.
105?
Yes.
Yes.
If you look at the page number 108, in the last part of the order, Your Honor. Therefore, the instant application filed by the plaintiff under Order 12, Rule 6, devoid of merit, and the same cannot be considered of as the statement made by the defendant under Order 7, Rule 11 does not amount to admission.
Yes.
To the,
What is wrong in it? Order 7 Rule 11, it's not an admission. It is not a petition for admitting or denying. How can you say? So what is this thing? There is no wrongful exercise of jurisdiction here. It's very much correct.
Okay.
Show us law that admission can be made in Order 7 Rule 11 application.
But they have not also denied.
Doesn't
the
matter. It is points of law. Show us that the statement made in Order 7 Rule 11 application can be treated as a statement of admission. Is there any law, any such law?
We have just relied on only on the statement made by them in Para 6. But since
So far as this petition is concerned, the part which you have pointed out, it only speaks about the reference of your statement by them in their Order 7 Rule 11 application. How can that be treated as admission? And this admission also has to come after a notice is issued, isn't it? That is what the Order 12 says. That when a party is called upon either to admit or to deny, isn't it?
yes,
Document. Where is that?
that admission has been made regarding the statement.
Where is? It is not that, madam, you are mixing up. You just show us a law that the Order 7 Rule 11 statement can be treated as an admission. Show us. Why it's a petition under 227? Why it's a revision under 227?
Pardon here.
Why your application is under Article 227?
It's just for the regarding any review regarding the decision made by the subordinate district council court.
No, but then there is a law for that, isn't it? So why 227 be invoked? 227 is this constitutional provision. Acha, it is read with Rule 6. So what is to be done? You have to satisfy the court, otherwise we do not see any illegality in the order. No error, no apparent error in exercise of jurisdiction by the trial
That
court.
the orders need regarding 227 is the the inherent power of the High Court to regarding to
Okay,
the
okay, it's all right. You have also invoked Rule 6. Okay, we'll see. That part is all right. But then show us that part, the admission part. How can the statement made in an application under Order 7 Rule 11 becomes an admission? Show us that. You have any law with you? Find out. Find out and come back. Tell us when can you do that. This court is giving you an opportunity. Try to find out.
in the next year.
Say clearly.
Rule 6 is to impose.
That is all right. So far as the maintainability of application, it's all right. You do not have to. Do not be bothered about Rule 6 and all. But then we are talking about the admission, which you are saying that they have made an admission in their application under Order 7 Rule 11.
Yes.
Now just give us a law which says that the statement made in an application under Order 7 Rule 11 can be treated as admission.
Your Honor, but if you give us next year.
That is what we are giving you. We are inclined to give you done. See, if you find out something, you will also educate the court. So when, how long, how much time you will need?
Okay, in the next year, give
1 week.
positive answer.
1 week, all right.
1 week.
1 week, all right. What is your name?
CL Mapla.
Miss Michelle, all right, counsel, appearing with the petitioner after arguing for some times. Praise for grant of some. After arguing at some length, praise for grant of some more time to prepare the matter. Prayer allowed. List after 1 week. Come back. You have to show us the law. Revision is not a matter of right. Okay. Unlike first appeal, revision is not a matter of right. So you have to satisfy the court.
Daily list, item number 1.
Please, Lordship.
Yes.
This is also a civil revision whereby your Lordships have been pleased to condone the delay on the last occasion. Mr. Khera was appearing. I had served the copies.
Then this revision
Lordship, here what
delay has been concluded.
delay has been condoned.
Okay.
Lordship, and it's come up for motion today. Here, my lord, briefly what had happened is the petitioner here, she's a defendant in an eviction suit before the assistant district judge. With regard to a premises situated at Police Bazaar, Lordship. That premises is still under the possession of the petitioner here. Suit has been filed for under the Meghalaya Urban Rent Control Act for nuisance and non-payment of rent. Now, your Lordship, WS had been filed before the learned trial court, and thereafter, the respondent, who was the plaintiff, had adduced two plaintiff witnesses, and the petitioner here, as defendant, my lord, had submitted a list of 8 defense witnesses.
The plaintiff witness is over.
Now, my lord, at the stage of examination of the DWs, the defense witnesses, what had happened is, Lordship, there were 8 in total. 1 was examined and cross-examined and discharged on 2 dates, Lordship. That was in the year 2019. Now, thereafter, Lordship, because of the onset of the COVID and other things, it could not be taken up for, did not proceed for some time. And thereafter, my lord, in the meantime, what had happened is a petition was filed to allow the defendant's witness to adduce the photocopies of certain treasury challans instead of originals, to exempt the
As secondary
as a
evidence.
secondary evidence, Lordship. Now, thereafter, Lordship, that petition was filed in the year 2020. It was duly registered.
Now, see, you wanted to exhibit some document, the original of which was not available. You filed an application for
Allowing me to produce the Xerox copies.
so it was allowed.
In Lordship, that was not allowed.
But that was not
It was not allowed.
Okay.
Why? Because, my lord, that on the day when the matter was fixed for hearing, the counsel before the learned trial court was absent.
Okay, you filed a miscellaneous application praying for
Yes.
allowing you to adduce secondary evidence.
Yes, so that was rejected on ground of non-appearance.
Okay, so it was dismissed for default.
Default.
Yes.
Thereafter, Lordship, I had filed another application to recall that order. And
Dismissal order.
Along with allowing me to re-examine the witness and to adduce further defense witnesses, Lordship. Now, there, my lord, thereafter what had happened, now this application, Lordship, was filed in the month of September 2023. Now, thereafter, Lordship, what had happened is, in the most unfortunate circumstances, Lordship, the counsel was changed in the middle of the pendency of that application. And the counsel who thereafter handled the brief lost the brief because of the fire in the Shillong bar premises. This I have stated with dates, Lordship, in February 24. So, as such, my lord, the certified copies came in the hand of the counsel of the entire brief on 12th of February 2025. And the matter was fixed
When
for...
this restoration application was filed?
Restoration application was filed, my lord, on 1/11/23.
Okay.
It was pending for about two
And when
years.
this counsel was changed?
Counsel was changed, Lordship, in the month of December 2012-23.
So within months only, one month only.
Yes,
Within
counsel
1
was,
month of filing of the thing.
counsel was changed.
And when this bar association was gutted by
This
fire,
was in February 24, my lord. So immediately after the vacation,
and when the new counsel was appointed?
in December. Application was filed in November. Counsel changed in December. Lost the file, unfortunately, in February, my lord. Then, what had happened is, Lordship, on 12/2/25, the entire typeset was handed over to the counsel from the filing section. copies of all the petitions, plaint and everything, Lordship. And the matter was fixed for hearing of this application to recall all those against that earlier rejection on 13th, on the next day. Now on 13th, my lord, in another set of unfortunate events, what had happened is, if Lordship would be pleased to see, here, my lord, in Shillong, the assistant district judge and the chief judicial magistrate are essentially the same judicial officer, my lord. She sits first in the CJM portion.
Studying dual
Dual
duty.
post, Lordships. And what had happened is the Hazira and the application for adjournment was filed on account that they have just received the copies a day before. So they have prayed for a next date. That application, my lord, was inadvertently put in the court of the CJM instead of the assistant district judge. Now, when the matter
These are all
was...
factual aspects.
These are
You see,
factual,
like,
Lordship.
which way
Now,
you'll prove
at
it?
the end of the day, my lord, the adjournment was rejected and the miscellaneous application was rejected on the ground that the council is not interested to
Where is
pursue
the
the
order?
matter. Lordship.
That is the order you are challenging here.
Lordship, yes.
Where is that order?
Lordship, that order is at... There is a certified copy. I have also enclosed it at Annexure 3, page 32, my lord.
Annexure 3, page?
32. And it begins on 33 is the...
Yes, small order, you can read it.
Yes, a record put up today. Learned counsel for the OP is so-and-so present. OP is found absent. Learned counsel submits that the matter be dismissed as this has been the conduct of the petitioner every time. So learned counsel also submits that the case had been dismissed earlier on account of absence of the petitioner and on the date fixed for hearing and restored back on the prayer of the petitioner being allowed. Learned counsel thus submitted that the case be dismissed. Later, at the time of passing this order today, learned counsel so-and-so appeared before this court at about 5:45 and submits a miscellaneous application filed for today to adjourn the case, in which the averments are
Okay, who is appearing for the other side
Mr. Khera was served the copies, but
of this petition?
Lordship, I had actually served at the time of along with the delay application. I'll take fresh steps, Lordship.
That is better. Heard, Mr. Learned counsel for the...
Prayer for stay of the suit, my lord. It's at the stage of final argument. Only to allow.
How DWS is closed?
DW is closed entirely.
How can,
Lordship.
where? By which order then?
By this order itself, Lordship. By this order itself.
This order is with regard to the dismissal of your miscellaneous application.
Yes, and thereafter, my lord, the matter has been proceeded for final argument. That I have stated in my petition, Lordship.
No, but then doesn't say DW is closed. This order.
No, that DW, this is the order by which I have challenged. That order by which DW has been closed, my lord, Lordship may have it at... I will just take your Lordship to that. Lordship, that order is not here, but the
So
matter
you have
is...
not challenged that order.
That is for
Was
final
it
argument.
not required that you should challenge that order? That appears to be more vital than this, what you have challenged here.
If Lordship would see the page 10, by page 11, paragraph 10, that was when the matter was fixed for not final
Page?
argument. Page 11, para 10. I have not enclosed that order, my lord.
No, but then that order is not under challenge also.
Lordship is.
Then?
In this petition, it is not.
Then?
Lordship.
Then?
But in, if I may just...
No, this is a problem. Your mistake and the litigant will suffer.
Lordship, at this stage, what I'm praying is if my miscase can be restored, then I can argue and...
But then can we do it without hearing the other side?
Not, Lordship.
And if DW is closed by separate order, there is a need to challenge it also.
Lordship, yes, I understand that, Lordship. In fact, the application which was been dismissed by this impugn order was also praying for recall of that order of 11123. That application is enclosed, Lordship.
Now, even if we allow this revision application, set aside this order of the order personal miscase, which way that will help you?
Lordship, I mean...
Until unless you are allowed to adduce DWS. And that order is not under challenge.
Lordship, because there's a small, if Lordship would see the prayer made in the misapplication, which has been dismissed at page 27, my Lord. And that,
Oh, you see what the prayer made here in this case.
the
You are
prayer,
saying that the DW was closed by a separate order,
Lordship, yes.
and this order is not under challenge. Now, even if we interfere with the order passed in the miscase, which way it helps you?
No, my Lord, what I'm trying to submit is, Lordship, that the order by which the DWs were closed was the order which was challenged in this miscellaneous application, along with the prayer to allow the defendant to adduce evidence. That prayer is at page 27, Lordship. And that prayer has been rejected.
You want to say that your miscase there was a prayer for recalling that order
Lordship, yes, yes.
of closure of DWS?
Yes, Lordship.
Where is that?
Page 27, I'm just reading the prayer, Lordship.
Okay, okay, 11/7/2023.
Lordship, yes.
Okay, hard, Mr. Dev. I can't say what issue notice. Returnable in 3 weeks. Petitioner shall take steps for service of notice upon the sole respondent within 2 days. Stop paragraph. As the matter pertains to reducing evidence of DWS in title suit number 7H of 2017. Comma. The further proceeding of the said shall remain suspended till the returnable date. List after 3 weeks. I'm obliged to take steps.
Item number 2.
Please, Your Lordship.
Yes.
Lordship, I'll be filing the objections and cause of the Lordship.
What is this?
Lordship, this is the application for restoration of a petition.
You're objecting to the prayer of restoration.
Yes, my Lord.
Just for the sake of objecting, or there's a reason for that?
That's the reason, Lordship. Lordship, I've already served the copy to my friend and I'll be filing in the cause of it.
Yes, Mr. Karwalang, Land Council. When shall we list it then?
Yes, Your Lordship.
When shall we list it?
2nd of March, Your Lordship.
Mr. Karwalang, Land
My Lord,
Council.
if it can happen on 3rd of March 2nd,
Yes, yes.
my apologies.
Mr. Karwalang, Land Senior GA appearing for the state respondent submits that the objection on behalf of the respondent. The objection in this matter will be filed during the course of the view. Stop. Today is 18th.
Yes, my Lord.
Come after 2 weeks. Just straightforward with the parties. List after 2 weeks.
Much obliged.
From civil bench costless. For mediation, item number 2. For mediation, item number 2.
Yes. Yes, Mr. Chakravarti. This has been listed for reference to mediation. So, if you do not have any objection,
Yes, it can go.
Where is the counsel for?
She's probably on
Our colony was there yesterday, and she said she has no objection.
Yes,
So just tell her that we are recording that.
yes.
But then she should be here. Somebody should be here. And she knows that matter is coming up today.
She's probably been on legs, madam. I'll inform madam.
Just say as agreed to by the Learned Counsel, appearing for the parties. The matter stands referred to the, what do you call it?
Mediation, special mediation. madam.
Special mediation. What is that? Yes. That will do.
Special mediation drive, madam.
Yes. Matter stands referred to special mediation. Right.
Oh, yeah.
For doing the duty. So just give it a try.
Well,
If you can solve your problem.
well, probably this notice of mediation, the registry will send to the. I think that is the system.
That will be done. That the committee itself will be informing which way and how is to be done. This court is not at all.
Well,
You inform Miss R. Kalani that
Yes, ma'am.
we'll be recording her appearance
Yes, madam.
before this court.
Madam.
Okay? So we'll not go absent these things. Record R. Kalani for such and such. Please inform her.
Yes, madam.
She is present here or not?
Yes, yes. I saw her in court number 2. madam.
Yes. Tell her. Just say, just in view of her submission, what Miss Maid submitted yesterday, we are recording her consent.
Yes, madam.
Item number 3.
Yes.
We have taken instructions, my lord. My clients are not willing to go for a special mediation drive, my lord. So
Can that be a basis for refusing referral?
it can't be, my lord, but I have to consult my clients. So they are not willing to go for. So my instructions are that much only, my lord.
Yes.
My lord, my clients
He
are-
had good plan for offering. But then what is the harm in going for mediation?
My lord, of course, there's no harm.
It
but,
was, I think that we expect that basically it was for you also to convince the parties. Because this mediation and all, until unless the lawyers cooperate,
yes.
court cannot do anything.
No, my lord, we have.
We can maybe at the best we can press the parties for mediation.
Yes,
but then
my lord.
ultimate settlement comes if you agree.
My lord.
And that is, you see, you have a vital role here.
My lord. We have informed my lord, saying that if doesn't work out, then come back to the court, my lord. But then my lord, they have given us instruction because I can't go beyond their instruction also. I try
No,
to
there is no
convince to
patience.
some extent, my lord.
Mr. P, when Learned Counsel appearing for the petitioner submits that the petitioner is not keen to get the matter referred to the special so and so. Paragraph. In view of the submission, this is the matter as ordered
My lord.
earlier.
My lord. Obliged.
From daily list, for mediation, item number 7.
On our part,
Yes.
we have no objection if this matter is sent for mediation.
No,
Golab Singh.
But this is also a service matter.
yes, Your Lordship.
This is with regard to that pension. And
Please
we
do something. These are old matters pending. If you are willing, you can do something. Give them
Lordship,
something.
actually, AG is the main.
It is the
Accountant
main
General Office is the main party, Your
That
Lordship,
is
in this
okay.
matter. They are not
Oh, Accountant General.
Accountant General. Yes.
Yesterday also this matter.
On last
On the
occasion,
last
also
occasion,
this matter was listed, but the AG office did not appear on the last occasion also.
Anyway, state is a party here, isn't it?
State is a part. State is just an appointing authority. You know.
Anyway, just say. Just say so and so is present on behalf of the petitioner, Mr. Karim for petitioner, Mr. Abram for the state respondent. Now appears for the respondent number 629. Stop. It appears that on the last occasion also, there was no appearance on behalf of the state respondent. Stop paragraph. The Learned Counsel appearing for the petitioner and the state respondent have agreed to get the matter referred to such and such committee. Stop. Accordingly, the matter stands referred to so and so for doing the needful. Just follow from those earlier orders. Please.
Hello, please, Your Lordship.
8.
Yes,
My lord,
Mr. Jha. Yes.
ready for the mediation, my lord. It's
Your Lordship, the department is not willing to go for mediation.
Wait. Why department is not willing to go for mediation?
Your Lordship, we've been only.
Is it not the duty of the department to try? Give a try? What is the...
my lord, this is
where?
with regards to the ACP and
Yes.
pay scale, my lord.
So that is basically concerning service benefit, extension of service benefit. Is it not proper for the department to...
Your Lordship, I've taken instructions. They said that they're not willing to go.
No, but then they are the state authority, isn't it? Not private individual. Is it a proper stand? When mediation is for the benefit of all the parties. You see, outcome will be basically a kind of win-win situation for all the parties, isn't it? If at all there is a settlement. Where is Dr. Mojika?
Your Lordship, he's on next before court.
This is a problem. He should have been here then. It is not that the petitioner is not willing. The private individual maybe has a right to do so. You are public authority. Which department it is?
Assam Rifle,
Assam
my lord.
Rifles, Your Lordship.
It is the casual approach.
Was sent for mediation before? Before? We do not know why you take that stand. You see, we do not know if you do not agree at all. Matter will come back for hearing.
Definitely, ma'am.
Why do we resist this prayer for mediation?
Your Lordship, then we can give it a try, Your Lordship, if that's.
That is the best thing.
Lordship, we'll try.
And that if you agree, then our works become easy, you see. We do not want to reflect in our order that this matter has been sent for mediation against the consent of the parties.
Your Lordship, then we can give it a try.
Anyway, just say HUD, Learned Council for the parties. MS Falcon, Learned Council appearing for the respondents. HUD, Learned Council for the parties. While Mr. Jha, Learned Council appearing, before Justice Mr. Jha, Learned Council appearing for the petitioner, has agreed. Has consented for reference of the matter. Come on. MS Falcon, Learned Council, appearing for the respondent submits that the department is not very keen for reference of the matter to mediation. Stop. However, she fairly submits that if the matter is referred to the mediation committee, that may not cause any prejudice to the department. Is okay?
Yes, Your Lordship.
Yes. Paragraph in view of the submission made with the parties, comma, this matter, comma, this matter also stands, this matter stands referred to such and such committee for doing the needful. Yes. 11 days.
Item number 9.
This can be referred.
Yes, very good. We like that approach. At least. You see, we do not know why that resistance is put to mediation.
Yes.
It's not, it will not prejudice anyone, isn't it?
No objection, Your Lordship.
State also. You see, we'll have to say, appearing for the parties have agreed, just like before that order. Stand referred.
Deeply, Your Lordship. Highly obliged.
10.
Yes, Mr. Khawalang.
Please, Your Lordship. Your Lordship, in this matter, we're challenging the order of the Lokayukta, stating that it doesn't have jurisdiction to pass such orders.
Okay, not a matter.
So I don't know whether it can go for mediation and how can it be settled through mediation.
Correct?
Yes,
Yes. The Learned Council appearing for the petitioner, appearing for the party submit that the matter involves question of law as to the power and authority of the Lokayukta, Lokayukta, and hence what is it? And hence the mediation, any mediation in the matter will not help the cause of grievance raised in this petition. Cause or stroke grievance raised in this petition. Yes, sir. Next paragraph. In view of the submission, list this matter as ordered, as previously ordered.
11.
Yes.
Please, Your Lordship. Your Lordship, the petitioners are not inclined to go for the mediation.
Who is the respondent?
Mr. Paske is appearing in this matter.
Why she is not inclined?
Lordship, as per the instructions, they are not willing, Your Lordship. 11.
What is the matter about?
This is a suit for recovery of money, Your Lordship, in respect of a land dispute, Your Lordship.
Boundary dispute.
Yes, Your Lordship. This suit for recovery of money, Your Lordship.
Is okay. Suit for recovery of money.
Yes, Your Lordship.
Now, what happens if the other side is ready to pay you something?
Lordship, it is the respondent who has filed a suit for recovery of money, Your Lordship.
There is a suit filed by respondent.
Yes, Your Lordship, in the District Council Court, Your Lordship.
Okay. So you are not willing to pay anything.
Lordship,
Not even the half of the amount.
as per the instructions, Your Lordship, the petitioner, whatever they say, Your Lordship.
Even if it
They
is
are not willing.
less than half, also that also you will not pay.
Lordship.
Okay. Yes. For you too, you'll be ready for.
Yes,
Okay. The Learned Council appearing for the petitioner submits that the petitioner is not inclined to get the matter referred for mediation. In view of the submission, mediation, get the matter referred for mediation. Any, it's okay enough. So in view of the submission, list the matter as ordered. Okay.
Hello, Lordship.
Hearing item number 4.
Please, this matter was actually tagged with the matter at item 10 today.
Okay.
Which the parties have not agreed for mediation. It arises out of the same order passed by the Lokayukta Lordship. So I'm praying this can be also heard along with that matter because all this while it has been.
Otherwise, it is tagged together.
It has been heard together, Lordship.
It is tagged together or not?
Not tagged by a specific order, but
But
heard.
then it is listed together.
Listed together always, Lordship. But today, this matter came for hearing and that matter
Okay,
came
just
for.
say then when that other matter will come up, when that item 10 is likely to come up. That Lokayukta matter?
I'll have to check the orders. I'm not sure.
This previous order, you have to go by the previous order when it was.
Yes, my lord.
Today, sir. It should be listed today.
It was listed for today also, for reference also.
Lordship, yes.
So then, so that means that in that order, then you have to modify that.
My lord, may I have both the matters after?
That is what, but then we have to say it there.
Yes.
Because it was otherwise also fixed for today.
Yes, my lord.
So it was not a special listing for referrals. Okay.
Well,
It is, of course, it has come under that column, but then it has not been. So in that Lokayukta matter,
That was item
after
10.
you say that, okay, in view of notices, so list this matter after 2 weeks. And then this also, as per from the London Council appearing of the parties, list after 2 weeks.
Lordship, yes.
Obliged.
I'm obliged.
Much obliged.
6.
Please, Your Lordship.
Yes.
Because I'm appearing on behalf of Mr. Pierre Pasquet, and I'm praying for some accommodation today since he's having some personal difficulty.
Very well, Lordship. After 2 weeks.
A prayer made on behalf of Mr. Pierre Pascal. London Council appearing for the response number
2 and 3.
2 and 3. List is matter after 2 weeks.
3 weeks. Your Lord.
3.
2 weeks. 2 weeks. 3 weeks is too long.
Any urgency in this matter?
Lordship, urgency is that here, my lord, the under the 144, under the 107 proceedings and 145 proceedings, an amicable settlement has been indicated. Now, that is affecting the parties to establish their rights in the civil court. So I was just praying for challenges that the
Amicable settlement made
Lordship,
in a 107 proceeding
Lordship, yes,
by the parties.
by the parties
Now this settlement is coming in the way of a suit.
of the suit and to
How
adjudicate.
can, but it is not by the same parties.
It's by the same parties, Lordship. But what had happened is that after that so-called settlement was done, immediately on the next day, the party had filed an application that this was not done properly. It was done under
Both the parties or one of the
one
parties?
of the party, Lordship.
That means you.
Yes. Now that application was never taken up.
Your diplomatic submission says so.
I'm-
Anyway, so you have initially agreed and then subsequently said you have not agreed. Okay, you have not at all agreed.
Yes, that is what I wanted to put in my application. Now thereafter, the matter was disposed of on the basis of that settlement,
Now in just 107 proceeding,
Lordship.
you agreed and that was disposed of on the basis of that agreement.
On that of that survey,
Okay, so next day you come
Lordship.
and you
No. Before the matter was disposed of, the joint survey was conducted. Joint survey came to the finding that both the parties have resolved the matter by amicable
okay,
settlement.
so that is not by way of any agreement.
Thereafter, I filed an
It
application.
was not by way of any specific agreement.
No, it was in the
That is by
inquiry
virtue of the report.
Report.
Okay.
I challenged that report before the magistrate. It was never taken up. Eventually, after about 2 years, when I wanted to withdraw the entire proceedings so as to claim my rights before the civil court, the magistrate said that in view of the settlement report arrived in 2023, the matter is disposed of. So that is creating a impediment, Lordship, insofar as the
So immediately after the report,
Lordship.
which said about settlement, the matter was not disposed of.
No.
It was kept pending.
Lordship, yes. My application
And thereafter, when you ask for withdrawal of that, they dispose it on the basis of that
of
settlement.
that report, yes. So now there is a challenge to the patta and a civil proceeding. Parties, the petitioner is not able to vent her civil rights because they are all constantly relying on this order, Lordship, that nothing survives.
That is for the court to appreciate
Lordship.
or not. We
Here,
cannot
my
help that cause.
Here, my lord, my only prayer was that the rights of the parties to claim their civil rights and interests should not be affected by this order. That is all that I am praying in this matter, Lordship.
Now it will be in addition to that whatever the executive magistrate has said.
Lordship, yes.
Can it be done by High Court? And whether it is proper for High Court to do so.
And that is the other part is, Lordship, that considering my
And we'll see the when you decide the legality and the validity of the order passed by. What is under challenge in this petition?
that not allowing me to withdraw that 145 proceeding, Lordship.
You are not challenging the order which was passed, not
That
allowing you to. So that means that order of disposal on the basis of so-called compromise or whatever it is, that is under challenge here.
Lordship, yes.
You are praying for setting aside that order.
Lordship, yes.
And with a further prayer to allow you to withdraw that thing.
To withdraw simplicity the entire proceeding altogether. Because it was never taken up for about 2 to 3 years, and in the meantime, suit was filed, nothing happened.
And that the report which was prepared, which said that there was a settlement,
Lordship.
was it done after you signed some document or you agreed?
No, there is
It
no
was
agreement.
not in
No, no.
any
This is just a
written admission.
joint survey report submitted by the authorities directly to the magistrate.
And you filed your disagreement to that
Immediately thereafter. That application also was never taken up. So when
And then it's a
nothing...
part of record.
Yes, that's all there.
Is it correct?
I'm not very sure.
Anyway,
After 2 weeks, Lordship, if I'm...
well, then if council is not...
Lordship.
All right.
2 weeks old.
No prayer made no prayer, Mr. Not council is paying for the response. State is also a party, Mr. Abraham.
Yes, respondent number 1, Your Lordship, yes.
Formal party only.
Yes.
Mr. Paske is for respondent number 2 and 3. On behalf of Mr. Paske, respondent is paying for respondent number 2 and 3. This is met after 2 weeks.
Much obliged.
Come with some law.
Lordship, yes.
At least say that this, even if the settlement made before, executive magistrate will not bind a civil court.
Lordship, party should...
And there should be some law. I don't think that you needed to approach this court for getting those kind of observation.
Because what had happened is, Lordship, before the civil court and all also, the entire WS filed by them is on the basis of this report. So it is creating a problem, Lordship.
But that is all right, but then that is because of the court which are not inclined to accept it or look at it or whatever the thing. See, normally, if it is a disposal on the basis of a compromise
Lordship.
or even a disposal without compromise,
Lordship. That should
you
not
see,
be an
the-
impediment for the
after
parties to
effect, you see,
agitate
like
their
civil
rights.
court cannot be made to, you see, it cannot be bound by this.
Absolutely.
This is not the matter.